Good morning. My name is Paul Bowen and I represent the appellant, Mr. Fletcher. We're here on a modification of alimony and the award of attorney's fees. Those are the two areas I'd like to talk about first. The appellant recognizes that that the opinion of the judge comes clothed with the presumption of correctness. Also, that the court is looking at an abuse of discretion, which means that no reasonable judge could have made that decision, which is an interesting standard because I think we all consider ourselves reasonable. In any case, though, there is a significant problem with this judgment. The court apparently was confused with a lot of the facts. One of the confusion is in the tires, the sell of the car on the tires. He said it was $171. The tires were bad, so he sold got a new car at $416, and that showed that he was being frivolous. That's not being frivolous. Not only is the facts not correct, but that's not even being frivolous. If you look at my client's financial affidavit, there is a deficit of about $2,200, and that deficit that's there really was never explained. My client, if you go through there, is spending extraneous monies on other things. He is obviously in a middle class, keeping his expenses down, trying to do the best he can with the money that he makes.
You acknowledge this at the outset.
I'm sorry?
You acknowledge this at the outset, that you were dealing principally with the fact findings that the trial court made. And on the alimony, I think that is your first point, right? Your client's living expenses, etc. The trial judge has given us a very detailed breakdown of his assessment of your client's claims, and concluded that your client would bring this burden of showing a material change in circumstances, the standard. And now you're telling us that he was confused, which sounds to me like an invitation for us to reweigh the evidence.
No, Your Honor, I'm not asking for it. I'm just indicating that the statements that are being made by the judge are not accurate as to the facts of the case. The absolute supported evidentiary facts show that my client did not sell the $171 car to obtain a $416 car. The lease ended. That was the first judge never gave him anything for the car to begin with. So taking the deduction out of the car is improper. The facts are that the competent substantial evidence shows that in fact this is an inequitable decision. I mean, he said that the health area that he was we failed to prove that it was unanticipated. And that's not true. The case law is that yes, you know it's going to happen, but the exact effect isn't. So the fact that his went up to this extent is not an anticipated debt, and that is
well. Fundamentally, the trial judge found that your client's expenses overall had decreased, and he explains those findings and ties them to what I think is competent substantial evidence in the record. So that's different than turning over to show that the unanticipated circumstances led to an increase in expenses, it seems that all the trial judge found your client proved was that his expenses went down.
He
And
said,
he even addressed the vehicle thing and noted that the overall automotive expenses had gone down by $290 a month.
if you look at the first the affidavit my client filed at the time of the trial, that shows that he had a $2,200 deficit. Now, if you go through and you pick out,
But that's not what we're here for. You're asking us to go back and review the sequence of these affidavits to come to a different conclusion about what they show.
no, Your Honor, I'm asking you to review the facts of the case to see that there is no substantial evidence to support the fact that my client did not have an increase. That's what I'm asking for, because that's exactly what happened. Is that he picked and chose between these things, and then he got confused about some of them and made deductions that he should not have made. And I mean, this court has the ability to review the facts and to review whether or not there's substantial competent evidence to support that, when in fact there isn't. Anyway, the other area would be the attorney's fees. We were denied attorney's fees because my client had $132,000 in his IRA account. The problem with the IRA account is that my client's IRA is pretty well static. The only way he can increase his numbers is to...
Well, and the judge made a finding on that that I think is key, which is the appellant wife is also running a deficit, and while she has a similar situation with regard to savings, retirement savings, as between the two of them, she's already found that she has an ability to pay attorney's fees from her earned income. And that, you know, as between the two of them, who's going to be forced to reach in to their savings accounts.
Part of the deficit, Your Honor, was the fact that she was putting money into her retirement account. In addition to that, the court specifically held that my client, that the $18,000 that the employer put in didn't count, that the HSA didn't count, that all of her benefits didn't count. I mean, that's what the court held, and that's not, that shouldn't be the law. It's not the law. That if you have a retirement account that the employer is putting money into, that employment account should count as as income. In addition to that, though, she had over $800,000 in a retirement account that had been going up continuously throughout this entire time. She also had in her financial affidavit extreme expenses for the children that were supposedly adults. That was discounted for my client, so it should be also discounted. But she has the overall ability to pay the attorney's fees based on her financial condition. The financial condition of my client, he's not going anywhere. His income is static, everything is static. He has to come to the court to ask for an increase. And if he doesn't come to the court for an increase, then he doesn't get an increase. As inflation goes up, his income buying power goes down. And so that it is unfair and I think inequitable, and I don't think a judge should consider all of the expenses. He didn't even discuss some of those expenses of the wife. And it's also interesting that the wife, every time she had a hearing, there was a reduction. The court in the omnibus order also found that her expenses or her income was $180,000. Now that I understand is a preliminary or is an interim hearing. However, that $180,000 was based on the facts that were present at that time. And that was only like a year before the hearing. One time she came in and asked for a deduction and because of a reduction, because of her COVID and a reduction. And it turns out that she made $50-some thousand more than she had the year before. So, I mean, just accepting her deductions is one thing, but if you look through there and you find her assets and how her assets go up, I believe is not proper. But I'd like to save some minutes for rebuttal if I can.
Yes, sir. 5 minutes. Thank you.
Good morning, Mark Baseman from Felix and Baseman on behalf of the Appellate. So again, this really is a standard of review case. I mean, if abuse of discretion means anything to this court, I think the outcome is predetermined. I think it bears noting that sort of the procedural history of this case, I think this all stems from the former husband feeling like he got an inadequate alimony award the first time around. That was affirmed by this court. The husband immediately turned around and moved for this modification, which has been being litigated for the better part of 9 or 10 years at this point. But even throughout the brief, you see the argument is it was inadequate to begin with, it was inadequate to begin with, it was inadequate to begin with. That's the core of this case, and this is a case that needs to end. One thing I do want to point out also is that the appellant has not provided this court with a full record of the underlying proceedings. The transcripts are excerpted. He's asking you to determine that there is no evidence whatsoever to support the trial court's findings, which is your standard of review. And that is simply impossible with an incomplete record of the underlying proceedings. So I think many of his arguments are completely defeated by that fact alone. When it comes to the attorney's fees issue, what you're hearing is it's not equitable, it's not equitable. There's an equality argument being made. I think that's a valid argument to make in an initial divorce where the parties are supposed to exit on the same playing field. But I think that changes as time goes on. As you come back for modifications, the duty of support isn't the same. In this situation, according to this court's precedent, disparity in income, disparity in assets alone is not grounds for attorney's fees in these cases. You first have to show actual need. And the judge did say, if I consider his retirement assets, he clearly has no need for attorney's fees. He has over $100,000. He can afford to have his own attorney. Now, the argument on this side is it's not equal, it's not equitable that he has to deplete his retirement assets where the former wife can pay from hers, presumably, but continue to build that out. I don't believe that's a legitimate legal argument, especially in a modification proceeding. Again, I would summarize that this is all an abuse of discretion standard, which ultimately is there any competent evidence at all that would support the court's findings? And would any reasonable human being make the same determination as the trial judge? People may disagree on how the outcome should be, but I don't think anybody could say that the outcome in this case was unreasonable given the record. I'm happy to answer questions or I'm happy to take my time.
No questions. Thank you.
Thank you.
Mr. Bowen, you have 5 minutes, sir.
Just the abuse of discretion is the standard, no doubt about that. But the question is what are the documents, what is the evidence that was shown to support that? And the evidence that was produced and the documents that were shown do not support the decision of the court, because the decision of the court picked and chose certain things out of the client's thing, and then did not even consider whether it was included in the first final judgment. He says, well, there was his food and so forth. that went down. But if you look at it, the final judgment, which is what he based it on, eliminates all food. That's not, I mean, whether you consider it an abuse of discretion, that is, to my way of thinking, is an abuse of discretion to take a situation and say there is no food included in here, and then say, well, just because you're eating now doesn't, that's part of your standard. That doesn't make sense at all. That is an abuse of discretion. And as to the fact that my client had 130,000, I do not believe that the law is that a person who has $800,000 is not responsible for contribution of attorney's fees, and I think this court had ruled on that in Tressner or something, Teaser or something like that. But in any case, ruled that way, where there was substantial assets in both parties, but the husband's was significantly greater. My client spends, if he spends, let's say, $60,000 on attorney's fees, then that 130 is reduced by 60 and will not be replaced. On the other hand, she gets money, let's say 800, she spends 60,000 on attorney's fees. The impact is significantly less. And I think that this court has been consistent in its determination that under those circumstances, attorney's fees should be granted.
Thank you.
Thank you.
Okay. Our next case is Ansner versus Tampa Electric Company.